Hello friends, welcome to ePathshala. I am Dr. Shweta Dhaliwal, Department of Political Science, Rajiv Gandhi National University of Law, Punjab. To introduce the topic, the module is dealing with two very important branches of international law / international relations, that is international humanitarian law and human rights law. Generally, it is understood that humanitarian law is more concrete, whereas human rights law is more of a philosophy. It's more fluid and vague. The purpose of this module would be, number one, to introduce the concept as well as the implementation part of the two laws, including humanitarian law and human rights as law. The second focus of the module module wants to introduce is the interaction between the two laws, which are actually defining the nature of international community wherein we are living. Also, the focus of the module would be the interdependence of these two branches of international law. Also, a slight misconception which still is in a fraction of international community nowadays is that human rights are more of a philosophy and they do not have any legal bent to them. In this module, the focus has been to highlight the different human rights courts which are working at international as well as regional level, or more on regional level. For example, the European Court of Human Rights, the Inter-American Court of Human Rights, the African Court of Human and People's Rights, etc. Also, interestingly, it is pertinent to note here that on the terms of humanitarian law, more of a legality aspect is being involved or invested into the growth of protection and promotion of. The objectives of this module are apprising you of the human rights, the concept, the principle as well as the law, apprising you of humanitarian law. The next objective is the similarities and dissimilarities between the two branches of international law, that is human rights and humanitarian law. And lastly, the interaction between humanitarian law and human rights law. International law has a number of branches which deal with the issues of war. International humanitarian law and human rights law are two of them. The former deals with the armed conflicts and the latter is found closer to the matters and issues of human security and dignity during peacetime. Before the two laws could be compared, it's pertinent to know about their origin and history. International humanitarian law. The rules of IHL are invoked during the armed conflicts. The Appeals Chamber of International Tribunal on War Crimes in former Yugoslavia defined armed conflict in its Tadic case, and the definition was, I quote, "An armed conflict exists whenever there is a resort to armed force between states or protracted armed violence between governmental authorities and organized armed groups or between such groups within a state." The term armed conflict has evolved over time and is eventually described as a relationship between states conducted by international law. Following developments in the field of international law, the international community needed to regulate the issues of war. The treaties which were adopted at the end of the 19th century and the beginning of the 20th century were the basis of international humanitarian law. For example, the Paris Declaration 1856, the Hague Conventions 1907 formulated the rules regarding conduct of hostilities. The second major step was adoption of Geneva Conventions of 1949, which remains the core of IHL, and their supplementary treaties, namely Protocol 1 and Protocol 2 of 1977. Although IHL primarily grants rights to the states, the conventions also provide protection for the individuals, civilians, sick and wounded individuals, including medical staff, military, religious personnel and prisoners of war who do not have a role in the hostility. In this historical journey, one of the goals of IHL has been protecting the civilians during the armed conflicts. In order to accomplish the goals, IHL focuses on two areas: limitation of warfare on belligerents and protection of individuals. Moreover, it is applied equally to all parties of an armed conflict, regardless of who started the fighting. Generally speaking, the rules of Geneva Conventions are applied to international armed conflict. However, only the common Article 3 of Geneva Conventions is related to non-international armed conflict. Moreover, the Additional Protocol 1 expanded the scope of international armed conflict and enabled that IHL is applicable to wars of self-determination or national liberation also. In accordance with the objectives of IHL, the International Committee of the Red Cross (ICRC) was mandated by Geneva Conventions and Protocols to organize relief operations and other humanitarian activities, protect victims of armed conflict, and visit prisoners of war. In addition, ICRC has a function of monitoring the implementations of IHL. The next is international human rights law. The developments in the American and the French revolutions affected many states, and ideas which were submitted throughout these events and occurrences were imported into the constitutions of various states across regions. However, the legal protection of human rights was an internal issue of a state and a part of constitutional law until the UDHR, that is Universal Declaration of Human Rights, was adopted in 1948. This introduced human rights law in the international arena and provided stronger protection for human beings. After that, international human rights law, namely international law concerning international protection of individuals, reflected in a number of specialized international and regional human rights treaties, principally in international spheres: International Covenant on Civil and Political Rights (ICCPR) of 1966, the International Covenant on Economic, Social and Cultural Rights (ICESCR) of 1966. In Europe, with the inspiration from the UDHR, the European Convention on Human Rights of 1950 came up. European Social Charter of 1961 came up. In Latin America or the Americas, the American Convention on Human Rights came up in 1969, followed by the African Charter on Human and People's Rights in 1981 and the Arab Charter in 2001. These rights are inherent regardless of their national, color, sex, race, religion, or so on of the people who bear them. International human rights law stipulates the responsibilities of the states to protect and promote human rights. In addition, so that the International Court of Justice has increasingly referred to human rights responsibilities of states in an armed conflict. Please refer to the first table in this chapter, wherein human rights and all their conventions along with their protocols have been mentioned, along with their date of adoption. The next part of this module is the relationship between human rights and humanitarian law. Some rights may be exclusively matters of international humanitarian law, others may be exclusively matters of human rights law, yet others may be matters of both these branches of international law. There are several points of similarity between the two branches of international law, that is, international humanitarian law and international human rights law. Some of these are enlisted, and they are: number one, both deal with individuals. Where human rights are concerned about individuals in peacetime or in situations short of war, the humanitarian law is concerned with the well-being and protection of individuals in conflict situations. Both laws may be invoked at the same time, as advised by the International Court of Justice in its advisory opinion in nuclear weapons case. In another example, IHL does not contain the definition of the prohibition of torture. Therefore, when the International Criminal Tribunal for the former Yugoslavia prosecuted for war crimes of torture, it referred to international human rights law. The view of the court in the Daleki case also confirmed that requirement of referral to human rights treaties is significant in order to understand and interpret the content of prohibition of torture. They are complementary branches of law. That's the next point. In the Cold War period of human rights law and the humanitarian law started affecting each other. For example, the UDHR led to the adoption of the Geneva Conventions. The Tehran Conference on Human Rights adopted a resolution on human rights in armed conflict. According to the complementary method of jurisprudence, or complementarity method, grants the humanitarian law and the human rights law that each one is applicable in all fields under the umbrella of international law. In other words, both branches of law are applied in accordance with one another. This theory is based on Article 31 of the Vienna Convention on the law of treaties, specifying that any relevant rules of international law are applicable in the linkage between the parties. In the Resolution 9/9, the Human Rights Council considered the complementarity of humanitarian law and human rights law and stated that when humanitarian law applies as lex specialis, the protection provided by human rights law should continue in armed conflict. The Diplomatic Conference on the Reaffirmation and Development of International Humanitarian Law from 1974 to 1977 was a response to the United Nations. The Diplomatic Conference and the two additional protocols of 1977 owed an undeniable debt to human rights, in particular by making some rights which are derogable under human rights law, non-derogable as humanitarian law guarantees. Both additional protocols acknowledge the application of human rights in armed conflict. Both are devoted to protect humanity beyond borders, religion, gender, etc. Several treaties of both the branches of law have a merger of both these laws. For example, the Statute of Rome clearly mentions the violation of different crimes: war crimes, the crime of genocide, crimes against humanity, and the crime of aggression. The Convention of the Rights of the Child is yet another example. The next point would be tribunals and courts to decide upon violations in case of human rights binding court decisions emerging in way of the regional courts like European, Inter-American, African, etc. And in case of humanitarian law, tribunals have been known to decide upon cases. The recent development of the International Criminal Court also greatly relies on the humanitarian law enforcement. Both deal with politically sensitive matters. The next point would be derogation clauses exist in human rights. For example, Article 4 of the ICCPR and Article 15 of the ECHR allow parties derogating from obligations in time of war or public emergency threatening the life of the nation. The right to life in this respect is regulated by their special provisions. Article 6 Clause 1 of the ICCPR specifies that every human being has the inherent right to life. No one shall be arbitrarily deprived of his life. Article 15 Clause 2 of ECHR restrains derogating from the right to life except in respect of deaths resulting from lawful acts of war. There are two formal requirements for the lawfulness of derogations. They must be officially proclaimed and other state parties to the treaty must be notified of them. Humanitarian law comprises rules prohibiting arbitrary deprivation of the right to life, but it phrases it differently. Article 15 and 15b of the Additional Protocol 1 prohibits an attack which may be expected to cause incidental loss of civilian life, which would be excessive in relation to the concrete and direct military advantage anticipated. In addition to the similarities, there are several differences in the two branches of specialized law. Some of the points are: humanitarian law fixes a degree of force which may be used in a conflict of situation and measures the minimum standards of safety to be ensured to the public. However, human rights law, on the other hand, deals with full-fledged respect of human rights and dignity of the people, and also in absence of conflict or military necessity situations. Humanitarian law is a negative law, while human rights are positive in nature. There are further more differences presented in the module. I highly recommend the students to refer to the module for further reading. There are further differences, and the next difference is humanitarian law displaces human rights in case of armed conflict. Humanitarian law is subject to a conflict situation and cannot be invoked without that being proved. Human rights are applicable during peace or troubled times, and sometimes even during wars and conflicts. Humanitarian law focuses on how to distinguish between the combatants and the non-combatants, and thereafter attaches rights and protection accordingly. In case of human rights, it considers everyone as human beings only, and therefore attaches all entitlements of human rights comprehensively without distinction. The conventions and treaties of humanitarian law as well as human rights law, separately adopted and enforced by their respective bodies. The theory of lex specialis was developed by the International Court of Justice to separate the humanitarian law from the human rights in order to handle conflict situations better. The ICJ stated in the advisory opinion 1996 in relation to legality of the threat or use of nuclear weapons that, I quote, "In principle, the right not arbitrarily to the deprived of one's life applies also in hostilities. The test of what is an arbitrary deprivation of life, however, then falls to be determined by the applicable lex specialis, namely, the law applicable in the armed conflict which is designed to regulate the conduct of hostilities. However, scholars debate over the idea of this is separation or establishing more deep relations between humanitarian law and human rights. Therefore, the debate continues. The next point is the means of human rights are vague and general in nature. Maybe they are more philosophical in approach, which make it difficult to be operative in conflict and emergency situations. International human rights law and international humanitarian law had little in common at their origin. However, the theoretical foundations and motivations of the two bodies of law differ. Human rights emerged as movement for rights within states. Human rights law, however, was primarily based on the reciprocal expectations of the two parties at war and notions of chivalrous and civilized behavior. We conclude certain things. Number one conclusion is the interdependence of the two branches of international law, in this case humanitarian law and human rights. In the module we discussed the similarities, and while discussing similarities we also discussed the similarity by virtue of their origin and their nature. We also derived similarity from the dependence and interdependence that these two laws have. It's very interesting to conclude here that the international organizations like the International Court of Justice and the International Criminal Court, including other regional human rights courts like European Court of Human Rights, etc., they have been articulating the dependence, the importance, and the equal footing of these two branches of international law, particularly humanitarian law and human rights law. It's also part of the conclusion to highlight that in addition to the similarities of these two laws, these laws also have a number of differences. Of course, we need to cherish these differences because that is why these two branches of international law remain to be two branches, otherwise they would become one. Also, the point of difference, the basic difference between the two branches is one can be invoked only if there is a conflict situation, which is proven conflict situation. The second aspect in case of human rights is that this kind of law or this human rights perspective is applicable even without invoking of any conflict situation. However, the biggest conclusion of this module should be that the concern of the humanitarian law as well as human rights remain welfare, protection, promotion, and dignity of those who cannot speak up for themselves. The purpose of these two laws is that no one should be deprived of his or her own self-respect and esteem.